Hello guys, and welcome to another episode of my lecture. On today's lecture, I'll be talking about the indoor management rule under the common law. We have the indoor management rule under CAMA, but this section as well as the next section will be discussing indoor management rule under the common law. In the next section, I'll be discussing about the exception to the indoor management rule. It would be the section after that I'll be discussing about the indoor management rule under the CAMA. It is very important for us to understand how the indoor management rule works, how it has always been under the common law. Even while discussing some Nigerian cases before the CAMA, it is important to understand what exactly this rule is about. And the indoor management rule has encapsulated the doctrine of constructive notice as well as the presumption of regularity. What are these two things? Let us start with our first case of Royal British Bank versus TURQUAND, where we are going to explain these two principles under the indoor management rule. The fact is that Mr. TURQUAND was the official liquidator of the insolvent Cameron's Coalbrook Steam, Coal and Swansea and London Railway Company. So when we are talking about the litigator, we are saying that the person who helps the company to wind up when the company is winding up. Do you understand? Winding up is the company law language for saying closing down. Do you understand? Like when you close down a thing, that's what winding up means. So the person who does the winding up for the company would be the liquidator. So in this case, Mr. TURQUAND was the liquidator. The director of the defendant company, that's Mr. TURQUAND's company, borrowed a sum of money from the plaintiff's bank on a bond bearing a company's seal. The company's deed of settlement as used here is the articles of association, just like in our old CAMA. So the company's deed of settlement said that the company might borrow money from time to time as the general resolution of the company authorized. However, there was no resolution passed by the company, but wealth was acquired from the bank. The board borrowed money and the bond was bearing the company's seal. In an action by the plaintiff company, that is the bank, against the defendant company on non-payment of money, the defendant put forward the plea that there has been no such resolution authorizing the making of the bond and that the same was given and made without authority. Do you understand this? So basically the issue was whether the company is liable for the loan. The argument of the defendant company is the company that the director took loan from the bank without authority. There should be a resolution passed by the board before such loan would be taken. However, no resolution was passed by the board, but the company's seal was on the bond. And then the question is, when the bank saw the bond, was the bank supposed to do something extra? Do you understand? The articles of association, but in their own language, the company's deed of settlement authorized the company to be able to take, loan from banks, provided that the company's seal is affixed on the bond which shall be used to take those loans from bank. However, it provides that before such can be given, before such company seal can be affixed on the bond, then there must be a resolution passed by the bond. The bank in this case did not ask questions as to whether or not resolution has been passed. What the bank saw was that the company's seal has been affixed and then the bank gave them the loan. Now the question is, would the company be liable for such loan where there has been no authority by the board authorizing the director to take such loan on behalf of the board? Do you understand? Now, getting to the judgment, Lord Hatherley observed that outsiders are bound to know the external position of the company but are not bound to know the indoor management. The dealings with company are not like dealings with other partnership. The person dealing with them is just bound to read the articles of association and the memorandum of association, but they are not liable to do more. The court rejected the plea of the defendant that the person is bound to read the statute and the deed of settlement and do more. The bank was held not to be bound to ensure that the necessary resolution in terms of the deed of settlement of the company has been passed. The company was held liable for the loan taken by its director on bond bearing the company's sale. Jervis J. stated that the parties dealing with companies are only bound to read statutes and the deed of settlement, that is the articles of association, but are not bound to do more. There was no prohibition on borrowing, but the permission to do so is on certain terms and conditions. Finding that the authority to borrow could be by resolution, the bank has a right to infer that such resolution has been legitimately done. The requirement of resolution was a matter of internal regulation for company, and the bank couldn't know whether such resolution has been passed, and they were entitled to presume that the resolution had been passed. This is the indoor management rule. This rule is a presumption of regularity, where a person dealing with a company is entitled to presume that all internal procedure regulation of the company has been complied with. They are entitled to assume that all act of internal management has been properly carried out. Outsiders aren't expected to peep into the internal affairs of the company, although a person dealing with the company should take care to see that the transaction isn't inconsistent with the memo and articles. He isn't concerned with the irregularities in the company's internal proceedings. For whereas he has means of knowing the content of the articles and memo, there are no special means available to him for discovering whether the company's indoor management is in order. He may presume everything has been done in accordance with the maxim that omnia presumuntur right et solemniter esse acta, meaning that all things have been done properly and solemnly which ought to have been done. It should be noted that the thrust of this rule is that even if outsiders has read and understood the memo and articles, he may not necessarily know whether those purporting to act on behalf of the company has authority to do so. The board of directors or general meeting may not have been convened, quorum may not have been passed, managing director or other directors may not have been appointed, etc. Under this seemingly complex situation, the law is that outsiders dealing with the company is bound to ensure that all internal regulations of the company have been complied with. Now, in this particular case, what was explained was more of the internal regulation of a company. That's the presumption that outsiders can make regarding the internal regulation. Do you understand? Now, this rule tells us that there is constructive notice. Do you understand? What is constructive notice? Constructive notice is where the company must have registered their articles of association as well as their memorandum of association. Upon registration, according to the common law rule, there is a notice to the general public as to the content of such memo and such articles. Do you understand? That is the doctrine of constructive notice. So if you apply the doctrine of constructive notice to this case of Royal British Bank versus TURQUAND, you would see that the court is telling us that where the memo has been registered, where the articles have been registered, third parties are bound by the content of that memo and of such articles. Do you understand? However, they are only bound to the extent of what has been stated in the memo and articles. So if the memo and articles authorize people to do certain things, then the third party can therefore rely on such to say, yes, we can move into this contract. Do you understand? If such memo and articles create conditions, like in this case, it empowers the director to take loan on behalf of the company, but such director must first get a resolution from the board, now that is a matter for internal management. According to this case, third parties are not bound by matters of internal management. They are only bound by matters that have been stated in the memo and in the articles. Do you understand? Even where it has been stated in the memo and in the articles that such loan can only be taken after a resolution, according to the court, there is no way the third party would know that such resolution has been passed. But according to the Latin maxim that I said earlier, they are presuming that all which ought to be done has been done. That is the presumption of regularity. We are presuming because third parties can't know what is done in the internal management of the company. Therefore, the court will presume that they've done it properly. They've done their internal organization well, and the third party can presume that yes, they can go into a contract. Do you understand? So I've explained the doctrine of constructive notice. Where memo and articles have been registered, they become constructive notice to the whole world as to their content. I've also explained to you what the presumption of regularity is. Where a matter falls within internal management, third parties can presume that such matter has been done properly, and therefore they can rely on such presumption while entering into contracts. Do you understand? So we've discussed the first case. We have 3 other English cases to discuss in my next video as to explain better this principle of the indoor management rule. So I will see you in my next lecture.